Hello everyone, welcome back to Believers Science Academy Bengaluru. This is topic of the day. In today's topic we'll discuss one of the most contentious or trending topic in India. That is an attempt to attack on Chief Justice of India, that is Gavai. We'll discuss what happened yesterday and what is the background to this incident and what is its ethical, constitutional as well as legal implications. So, attack on CJI Gavai and the challenge to judicial independence. First, why the question arises? It is because of the temple in question. The temple in question was Jawari temple. I will explain you. What happened was there was an advocate who put PIL, that is public interest litigation, with regard to a particular temple, that is Jawai temple in Khajuraho. Jawai temple in Khajuraho, which is a part of UNESCO World Heritage Site complex in Madhya Pradesh. UNESCO World Heritage Site complex, it is one of the temple in that complex. Okay, within that temple there is a statue that belongs to Lord Vishnu, and the statue's head has been decapitated during invasions. We all know the invasions which used to happen during the kings and the conquests between Arabs or the Turks or the Muslim invaders and Hindu rulers. So one of those conquests led to decapitation of head of the Vishnu idol. So this public interest litigation said that they wanted to restore this head so that the Vedic traditions or the Vedic sermons of the temple can happen there, so that the pujas can start in temple again. Okay, that is the issue. That the idol was reportedly beheaded during the Mughal period and has remained unrestored despite several appeals to authorities. Okay, so that was the public interest litigation by a advocate. So this is the temple in question, a beautiful temple belonging to Khajuraho dynasty, belonging to Khajuraho Nagara architecture. Okay, belonging to Khajuraho Nagara architecture, and this is the Vishnu idol that is in question. You can see the head of Vishnu idol is missing here. It has been decapitated or beheaded during the Mughal period. So person PIL wants to restore it so that the pujas can happen in the particular temple. But when the PIL went to CJI, what was CJI's reply? CJI said that it is not public interest litigation, it is publicity interest litigation. The case was heard on September 16, 2025, and CJI Gavai said that what you brought in front of the court is not public interest litigation. Instead, it is a publicity interest litigation. You want to gain publicity out of this particular case. And he again remarked that this is purely a public interest litigation. Go and ask the deity himself to do something. If you are saying that you are a strong devotee to Lord Vishnu, then you go and pray and do some meditation and restore it on your own. Okay, see the language of CJI. Okay, see the language of CJI. Doesn't matter whether it is public interest litigation or whether it is publicity interest litigation. As a CJI, as a supreme of the judiciary of whole of India, is or are these the words that has to be used by a CJI? Aren't the words are going to hurt a particular religion, in this particular case Hinduism? You are asking, if the God is so powerful, why doesn't he restore his head again himself? If he was such a big devotee, why don't you do meditation and ask it to restore its head itself? These comments were made in the context of Archaeological Survey of India's jurisdiction over the temple's upkeep. Court said that, CJI Gavai said that the question you are bringing in front of Supreme Court should have went to Archaeological Survey of India, because restoring a head of an idol in a UNESCO World Heritage Site is the prerogative of Archaeological Survey of India, not the Supreme Court of India. If he had said this, then it wouldn't have been a big issue. But what he said after this, it is jurisdiction of Archaeological Survey of India, and so go to Archaeological Survey of India instead of bringing PIL to judiciary, instead of bringing pendency to judiciary. If that was the case, it wouldn't have been bigger controversy. But his remarks afterwards, that ask that God to grow its head back, go and do meditation if you are such a big devotee. This is what sparked tension. Okay, so these remarks were criticized throughout India. Next, public backlash and clarification. This obviously sparked widespread criticism on social media, with many interpreting them as disrespectful to Hindu sentiments. Obviously, some of the Hindu people who are orthodox in nature are going to get hurt by this, are going to get their sentiments hurt because of these statements. In response to the backlash, CJI Gavai clarified on September 15 or 18, 2025, said that I respect all religions. This was his remark. I respect all religions. And it was supported by Tushar Mehta, who is the Solicitor General, also defended Gavai. He said that the comments were taken out of context and the CJI has always shown respect to all the faiths. These are post-mortem kind of things. The damage has already been done. Now what they are doing is they are doing post-mortem of reducing the damage. Okay, but obviously whenever there is a statement belonging to or pertaining to any religion in India, which is a religion loving country, obviously it is bound to create controversies, obviously it is bound to create eyebrows, obviously it is bound to tilt heads across India. That is what happened. So on October 6, 2025, during a Supreme Court session, an advocate attempted to throw a shoe at CJI Gavai in protest of his earlier remarks. Okay, his name was Rakesh. Rakesh was the advocate. He initially threw the paper towards CJI and tried to throw the charge, like his shoes, but he was held by the authorities there. And his remark was, the advocate shouted, Sanatan ka apman nahi sahenge. What does this mean? We do not tolerate insult to Sanatana Dharma, in this particular case Hinduism, before being restrained by security personnel. We do not tolerate insults to Sanatana Dharma, be it to CJI, be it Prime Minister, be it President, be it anyone. That was his remark. The Bar Council of India suspended the advocate from practicing in any court with immediate effect following the incident, and he was arrested as well. But today morning, CJI has said or has asked him to be released. He is released and all his belongings have been released, and Supreme Court of India has abstained itself from putting any cases on him. Okay, so they have not put any case on him and he has been released now. So that is the current context. But so the Bar Council immediately suspended him under Advocates Act of 1961 and BCA rules on professional conduct and etiquette. Supreme Court Bar Association condemned the act as a direct assault on the judicial independence. This is not an attack on the CJI, it is not an attack on a particular judge, but an attack on judicial independence. And he also said that such conduct violates mutual respect that sustains bench bar relationship. This is what the court or the implications or legal implications were after the immediately after the shoe incident. Now, constitutional dilemma or constitutional dimensions. Judicial independence is part of the basic structure doctrine of Indian Constitution, which was held by Supreme Court or judiciary in the Keshwananda Bharati case. So, judicial independence is the cornerstone of basic structure doctrine. So, the question arises: an advocate belonging to judiciary throwing shoes at a judiciary, does it undermine judicial independence? That is the question has to be answered. Next, in Article 50 mandates the separation of judiciary from the executives. Okay, so here there is no involvement of executive in the judiciary, instead it is the involvement of judiciary in the executive, you can say. Okay, judiciary is going beyond its judicial competence and is going into an executive domain, and it is talking about secularism. Though the Indian country is secularism in nature, it is also a religion loving country, be it any religion, Hinduism, Christianity, Islam, any kind of religion. They are strongly held in India. And the preamble, which upholds secularism, justice, liberty, and equality, values are being threatened by such intolerance. So that is what the constitutional dimensions of this particular incident is. And the act undermines rule of law, which is a foundational constitutional principle. And many opposition parties called that the constitutional morality is on the down in India. So political and societal require reactions. So Mallikarjun Kharge, the opposition leader, called this shameful. He said that it is reflecting fanaticism and bigotry in the society. And Sonia Gandhi called it an assault on the constitution. And Kapil Sibal criticized the silence of government leaders. But today morning, Prime Minister Modi has condemned this particular incident on CJI and he called for respect towards judiciary. Next, leftist leaders like CPI, CPIM have viewed it as a communal and casteist intolerance, pointing to Dalit identity of CJI Gavai. Okay, any instances in India which becomes controversy is turned politically by each parties. So Congress tried to, or like INC tried to point out the fanaticism, and Mallikarjun Kharge said that it is also an ideology which is promoted by RSS. Because of this RSS Sanatana Dharma ideology, this has led to a wrong intolerance. Whereas CPM or the leftist leaders tried to portray the caste identity of this particular leader, but not particular judge. Because the judge belongs to Dalit community, they say that the attack on this judge was made by the ruling party. That is what opposition are saying. Okay, not that is not important for us, but that is the comment from opposition parties. Next, this is what is very important from judicial UPSC perspective. That is, does judges have the authority to comment on the religious sentiments? A question of judicial boundaries and the constitutional balance. Okay, we will see this. Do judges really have the authority to comment on religious sentiments? Do the judges have the authority to make harmful statements regarding the religious sentiments? We'll discuss. Okay, the core issue that his remarks on Vishnu Idol restoration case reignited the sensitive debate that should judges express opinions that may touch upon religion or faith? Obviously, they can. There have been many instances where the judiciary has tried to bring social reforms in the religion, but this case is different. This is not about reform, but this is in distaste towards the sentiment of religion. Next, while the judiciary interprets laws rooted in religion, such as temple management, personal laws, faith-based rights. For example, in faith-based rights, we can talk about waqf. In personal laws, we can talk about triple talaq. In temple management, we can talk about any particular temple. For example, Kashi Vishwanath or Kashi Vishwanath temple issue that is happening. Okay, and rooted in religion, any perception of bias or insensitivity can erode public trust in judicial impartiality. Okay, what should be the judiciary focusing on? Judiciary should focus on secularism. That is not the Sarvodharma Samabhava secularism, but detaching itself from any kind of religion. Detaching from religion. What should the judiciary do? When it detaches from itself from religion, it should do so in impartial manner and non-partisan manner. Okay, impartial or without any bias in a non-partisan manner. But questions arises when the judiciary or the CJI talks in distress of particular religion. That is what the question is being asked here. Constitutional context. Under Article 25 and 28 guarantees freedom of religion, while the preamble upholds secularism, which demands neutrality from the states and judiciary alike. Though the citizens have the freedom of speech and freedom of religion. In Article 25, you have the freedom of religion. In Article 25, freedom of religion to practice, profess, and propagate religion. And 26, you have the freedom to manage and administer a religious institution. In Article 27, you have the right to profess or propagate religion, and you cannot be taxed for it. And Article 28 talks about religious instructions. So these mainly deal with citizens and administration. But the preamble talks about secularism, which means there has to be neutrality from both government as well as judiciary. Judges who are considered as constitutional guardians are bound by the principle of judicial restraint. That is, they must interpret and not preach. They must interpret and not preach. What happened in this case? There was there was a small hint of preaching by Justice Gavai. Yet Article 19(1)(a) protects freedom of speech for all citizens, which includes judges as well, though their speech carries institutional weight and must reflect constitutional morality and must consider sentiments into consideration given their institutional background. Next, when judicial speech becomes sensitive, remarks on the matters of faith, even if legally contextual, risk being misinterpreted as ideological or religious commentary. This is what is happening in this particular case. This particular case is being seen as a religious commentary rather than a legally contextual legal words. Such statements can unintentionally polarize public opinion and invite backlash, as seen in the particular CJI case. And the danger lies not in the intent but how the public perceives it, that is the public perception, where judicial language can be weaponized in political and communal narratives. That is what is happening in the particular case. Ruling party or the people belonging to ruling party perceives it in a different way, and people belonging to opposition party perceive in a different way, and the common citizens perceive in altogether different way. So how the citizens or the public perceives these things becomes very important here. Next, a comparison on contempt of court and religious sensitivity. Okay, we all know there is contempt of court, though it is not explicitly mentioned or explicitly mentioned in the Constitution of India. It is implicitly present that the judiciary carries a sort of sanction. So any action which is bringing threat to the sanctity of the judiciary amounts to contempt of court. Within contempt of court, there is civil contempt of court, there is criminal contempt of court. In civil, you are not upholding or you are not doing as the judiciary has asked you to. In criminal, you are vandalizing judiciary. In criminals, you are like bringing some sort of negative connotations of judiciary. There are some actions. One is when you are not upholding the judicial action, when you are not bringing complete justice, judiciary is considered as civil. In criminalizing, when you vandalize the judiciary, when you bring negatives to judiciary, when you like stop a judicial administration, those are considered as criminal. So any question on the contempt of court is decided with the court. So any action which undermines the sanctity of the court is decided with the court, which amounts to contempt of court. But any action by the court which undermines the sanctity of a religion, which undermines the sanctity or the trust or sentiment of the public, sentiment of the citizen, what does it mean? Is it meaning the contempt of religion or does it mean contempt of the citizenry? We'll discuss. So the nature on judicial remarks on religion and the contempt of court expressed during the judicial reasoning or oral observations. In the contempt of court, it is a punitive tool to protect the authority or the sanctity of the courts. Intent behind the judicial remarks is interpretation or contextual remark, whereas the intent is to deter disobedience or defamation of judiciary in contempt of court. And the public impact may unintentionally hurt religious sentiments in judicial remarks on religion. That is what happened in the current case, and may suppress free criticism under the scandalizing the court. Next, irony that judges are protected from public attack under contempt law, but public cannot question their remarks freely without risking the contempt. That is the irony here. That is, judges are protected from the public attack in the contempt of court, but public cannot question the action of the judiciary because without risking the contempt, because they will be considered as contempt of court and they will be punished. So this asymmetry raises an ethical question. That is, can the judiciary claim protection from criticism via the contempt while exercising moral authority over religion? Okay, any question which undermines or sanctity of judiciary comes under contempt of court. But what about the action of judiciary which undermines the religion? What about the action of judiciary which undermines the public sentiment? What does it mean? Okay, so that is the question. There is a fine line between judicial independence and judicial accountability. That is, judicial independence must coexist with judicial accountability. I will tell you a case. So there was a Nupur Sharma case. Okay, Nupur Sharma. There was a TV debate which happened between Nupur Sharma and a Muslim Maulvi. There were arguments between both the communities, both the religion, and she said some things about Prophet Muhammad, and which was considered as a very contentious topic. So there was a huge uproar over the India, and which ultimately led to death of some people as well. So communal death as well. So in this case, judiciary intervened, and called the words of Nupur Sharma as slip of tongue. Okay, so you should hold your tongue, which should not be slipped like this, which will lead to communal tensions. So judiciary criticizes Nupur Sharma because her actions led to communal tensions, which led to death of an innocent person. So, because her actions or her words were in distress of a particular religion or community, it was called as slip of tongue. But no, there was a comment from the CJI himself, which had the potential to bring communal violence or which had the potential to undermine the sentiment of a particular religion. What is it? Is it the slip of tongue or is it just a judicial context or judicial interpretation? That also has to be addressed. That is, judicial independence must coexist with judicial accountability. If you are holding a person accountable because of his comments or because of his words or her words, why are you not holding yourself accountable because of your words? Though there is judicial independence, okay, you are free to use your words, but if that word leads to threat, if that word leads to communal disharmony, are you going to hold yourself accountable? That is a question that has to be addressed. The legitimacy of courts rests not on the fear of contempt, but on the power of reasoned restraint. Then, overreach into sensitive religious commentary risks appearing moralistic rather than constitutional. Okay, what is judiciary for? To uphold constitutional validity. It is not here to preach morality. It is not here to bring morality into society. It is to uphold constitutionality. So the recent comments were seen from the morality perspective. That is not necessary from the judiciary. So the way forward, what should be the way forward? To avoid such huge debates or huge sparks, judges must speak through judgments and not opinions. Stick to judgments and not opinions, especially in faith related cases, especially cases which involve sensitive religion. Institutional self restraint and conceptual sensitivity must guide the courtroom language. Next, reforming contempt laws to allow fair, reasoned criticism can strengthen, not weaken the judicial credibility. Because judicial accountability has to be upheld as well. Any criticism of judiciary, be it with respect to pendency of judiciary, be it with respect to vacation of judiciary, be it with respect to daily hours of working hours of judiciary, that has to be seen in a fair taste. It should not be seen as a criticism of judiciary, it should not be seen as a content of judiciary, it should be seen as a fair criticism by the individuals, fair criticism by the citizenry. Next, concluding view is the judiciary's moral authority flows from impartial silence and not moral sermonizing. So, while judges have constitutional freedom to reason, faith and law must be balanced delicately. For in a diverse democracy, even a phrase from the bench can echo far beyond the courtroom. That is what happened in the current case. So, the judiciary should exercise restraint in cases where there is religious sensitivity involved. So this is the current topic of the day. So if you have any differing opinions from my opinion, be free to write your opinions. Be free to criticize my opinions as well. The comment box is yours. It is open for you because UPSC respects opinionated person. Always bring your opinions into the fore. With this, I will end the video. Jai Hind, Jai Karnataka.